Mr Kirby.
My Lord, I wonder if I might be permitted to make three, what I hope will be very short points. And they're in part to address points that have been put to me rather than new arguments. So far as cross-checking of ticket numbers with spreadsheets are concerned, can I just take my lordships to divider, this is supplemental bundle 2, divider 35. Paragraph, this is the affidavit, by the way, of Mr Ahmad, so on behalf of Times Travel. But page 251, paragraph 13, is dealt in the previous paragraphs, which I think we have looked at, with the spreadsheets being cross-checked. And at 13, he says, ticket numbers and the cost price were also cross-checked with BSP reports, which are third-party reports generated by IATA. The BSP reports from the, not sure what that means, the BSP reports, from the purpose of this period are the same ones PIAC have provided, as they are not disputed in terms of raw data, ticket number and cost price. And some very similar statement at page 262, which is after divider 37. Paragraphs 14 and 15. This Excel spreadsheet was then cross-checked with PIAC's Excel spreadsheet. The cost of the ticket and ticket number was cross-checked to see if it matched PIAC's Excel spreadsheet, which mostly did, and any differences were nominal. And 15, the ticket numbers and the cost price were also cross-checked with the BSP reports, which are third-party reports generated by IATA. In this instance, they were cross-checked with BSP's supplied by PIAC and NTL versions. The ticket data in both are identical, and as expected, as they are BSP reports provided by IATA. So we say that the evidence before the court on the taking of the account was that the BSP documents could have been cross-checked against the spreadsheets and the schedules that have been provided, and that's confirmed by the claimant's evidence. My second point relates to the slip rule judgment. And I know my lords have read the slip rule judgment, and my lords will have seen the conclusions that the judge who took the account came to with regard to the error. But my lords have queried whether, in the sense, the relevance of that. My lord, we say it is relevant, but even if we're wrong on that, we say it must be relevant to at least this point, which is what we understood to be an issue for the purposes of this appeal. So we have not put before the court lever arch file after lever arch file of the spreadsheets and the BSP data from IATA, because our understanding from the slip rule hearing and the slip rule judgment was that the way in which the claimants put the case was that a particular direction had altered the way in which the account was to be taken. So I was, and been critical of everyone, it's about time I was critical of myself. I was not necessarily expecting this morning to spend most of my morning dealing with, well, how do you prove that the tax was included? Because for the purposes of the slip rule application, it appeared to be accepted that the tax had been included, but there was a different basis upon which it was then said that that was still legitimate.
But as I understand it,
on the slip rule application, Mr Malek's evidence was relied on.
Mr Malek's evidence was relied on there, yes. But, well...
Whereas you're not relying upon it before this court.
No, but I have not put before this court in numerous supplemental bundles the documents that were before the court on the taking of the account, which would illustrate...
But it would just be more of the same kind. I mean...
Well, no, my lord, forgive me, because it would be... I probably didn't need to put volumes and volumes before, but one of the points that had concerned my lord this morning was whether I could show from the BSP that the figure there in relation to tax had been included in the figure that was in the schedule, in the spreadsheet. And that could have been done, obviously, by simply producing to my lords those relevant spreadsheets and BSP reports. Now, I accept those have not been put before the court, and the reason why they had not been before the court, one was because of the volume of them, or they could have been produced electronically, I suppose, but because we did not understand that to be an issue. My third point, and in a sense it's taking up a point that made by my Lord Justice Birss, which is if obviously finality trumps the ability to correct a mistake, then obviously the loss falls on us. But what we submit in this case is that this court could and should intervene so that the loss doesn't fall anywhere. There's no need for the loss to fall anywhere. I mean, if, for instance, 2 additional numbers have been added at the end, purely by mistake, it would be surprising, we would submit, that an extra decimal place was not something that could be corrected in this court. My Lord has very kindly given me that short period of time after the lunch break. I don't know if there's anything in particular I can assist further with.
No. Thank you very much. Mr.
Thank you very much.
Mr.
Lords, to begin with, I hope you received an updated skeleton from me last week with the correct bundle references. There was a slight change of bundle references between preparation of my skeleton and the one that was filed.
I did. Yes, it looks so ordered. Thank you very much.
My Lords, I propose to first address the questions that have been put to my learned friend in terms of the evidence available. And then, because I think it will assist the court to give a brief outline of the shape of the account, because the court has only had a partial history of it to date, with a particular focus on the definitions that are relevant, where YQ comes from, what YR is, etc., etc., before then going on to why this appeal ought to be dismissed. My learned friend was asked, is there evidence before this court to demonstrate that there was an error made? And the short answer is no. The only evidence that would demonstrate an error was made was Mr Malek's evidence, which we're now told at the court's door, despite its inclusion in the bundle, my learned friend does not seek to place any weight on. What is before the court, and I will take you to later as we're going through the shape of the account, are those sample or example schedules that were attached to witness statements from my clients, the notices of objection, and some BSP reports. But other than that, it is a matter of inference. And my learned friend has fairly conceded that the account bundles are not before the court. Now, as the appellant, it was incumbent upon them to to the court the evidence that was necessary to make out their case. The idea that Mr. Malik's witness statement was accepted can be clear from, I don't see how that conclusion can be drawn from my skeleton, which is clear that the court should dismiss it. And that absent Mr. Malik's witness statement, that it would be necessary to have the full account bundles before the court. And yes, they're not capable of printing, but they are capable of electronic management, as demonstrated by the 2 days of the account. Perfectly manageable. In terms of what the second question is, was the evidence before the court below, even if it's not before this court, that would have allowed the error to be identified? Now there are, in relation to that, my own friend prays very heavily on the BSP reports. And I have checked this morning, those we're content that those were in the bundle. There is, however, as we've discussed earlier this morning, no explanation of any element. And that is important because despite 2+ years of litigation about the basis on which NSR ought to be calculated, the idea that it was calculated off gross fair cash was never raised. So the relevance of this column would be a matter that would have to be established by further evidence. There is then also the question of the column entitled tax/fee cash. Otherwise, if you want an example, page 318. Tax/fee cash is a challenging category for 2 reasons. And the first is that there's no suggestion that fees, whatever and however they should be removed from a calculation of NSR. My own friend's case is simply that taxes, we'll come on to what taxes mean, should be removed. So this column would have to have some exploration as to what the fee elements were. The second element is tax. Now, unfortunately, this is not the case that taxes are objectively verifiable as ones that are imposed by government bodies like VAT or passenger duty. Taxes, as can be seen from the YQ debate, are those things which are simply given a tax code. I can't, and no one can tell you from this document which column YQ is in. But it was, prior to the 2017 trial, coded so that it would be excluded from the fares on which commission was given.
When you say coded, can you just explain what you mean by that?
As in, by being called a fuel surcharge and YQ, PIA sought to say that it was a charge properly so called and therefore was not part of the fare applicable. and Mr Justice Warren's judgment in 2017 on the YQ issue was that fuel surcharge, coded YQ, was something on which commission ought to be given. It was, or it ought properly to be, part of the fare applicable. What this means is that if this was remitted back, there would have to be evidence from someone as to what was included in these columns. And my learned friend says that this could be remitted back without any evidence. Given that gross fare cash was not a term that the court considered at any point prior to the taking of the account, it's not clear how the account judge could form any view of it. But alternatively, if the court was minded to remit this back on the prohibition of further evidence, just for example, it wouldn't assist PIA at all. And that's because this is an account. The spreadsheets they filed in January 2019, as defective as they were an account. They continue to believe, as your lordships heard, that they were simply a document to allow us to see whether the discounts had been taken. That's not correct. I'll take you to the order later, but it sets out quite clearly the obligations of PIA to provide a document in compliance with Practice Direction 40A. And that's why there are notices of objection to it, and all of the usual steps they need to provide vouchers to the BSP reports are all present, because the 2019 spreadsheets were the account. And so if we remit this back to some poor trial judge to deal with without any further evidence, what will he have, she have before him? They'll have the 2019 spreadsheets. They'll have our witness evidence. Now that didn't include spreadsheets, that just included tables of what we thought the money ought to be. And they'll have the analysis spreadsheets that the claimants filed handling PIA's data, where they went through and analysed that data in order to demonstrate why we could invite the court to find that no discount had been given. And I will take you through those documents and those spreadsheets. Even if the claimants formed the view that they didn't want to rely on any evidence they had positively filed as to the amounts due, their witness statements, which my learned friend places a heavy weight on, they would still be able to rely on the account filed by PIA. And there's no suggestion that those numbers would change. There's no suggestion that I would be obliged to say to the court, actually, you know what, those numbers are a little high, they ought to be brought down. PIA are the accounting party. If they have put in numbers that are incorrect, that is their mistake and their lookout. But
well, indeed, and Mr Kirby acknowledged that. He acknowledged that the mistake had started with them. And I appreciate the point you're taking is that they're seeking to falsify their own account. But that's the premise of the argument. That's accepted, that's what they're trying to do.
I'm grateful, my lord.
But so then the question is, well, should they be allowed to do that or not? I mean, I appreciate your you're gearing up for a submission that they shouldn't. But at least in theory, subject to questions like finality, debarring orders, and so on, which I appreciate are major points. If we put those on one side,
Yes.
an accounting party can still say, actually, I've made a mistake in my account. I mean, in theory, you could do that.
If you were at trial and we leave aside the small matters of debarring orders, etc., then yes, an accounting party could turn around and say, actually, we do need to falsify our own account. The extent to which that would be received by the judge, I suspect, would depend on why they were doing it, why they find themselves in that position, particularly given it should be supported by vouchers. But I don't see there's anything that would prevent the court from hearing and considering that submission, no. The final point, just to pick up on what my learned friend said about the substantial windfall. Because he made the point a number of times that my clients have allegedly obtained a substantial windfall of £2 million. That is only if the court accepts the evidence of Mr. Malik. Absent that evidence, my learned friend's submission is just pure submission.
I mean, it goes a bit further, doesn't it? In the sense that if what Mr. Kirby says is right, then the gross fair cash figures will tally with your... I'm sorry. The payable balance figures will tally with your sales figures.
Yes.
We can discern that the payable balance figures include tax/fee cash. We may not know where my Q is, but it's a pretty fair inference that the figures include APD, because that's tax. If NSR means what Mr. Kirby says it means, then you're getting too much.
My lord, there might be, I think we come back to the point that is it possible that if PIA were to rerun this and put in all of the evidence, they would have obtained a better result for themselves? Well, the answer probably is almost certainly, because an account that isn't defended, and although on the matters of discount there was pretty extensive discussion on that, PIA were obviously heavily restrained from what they could do. So if the question is, could PIA have obtained a better result if they had put in better and or different evidence and or participated in the account, then the answer has to be yes. Lord, turning then briefly to, if you like, the shape of the account chronology, simply because issues arose in terms of things like revised NSR that I don't think have been rooted properly where they ought to be. The original pleadings, which I won't take you to, are at core bundles tabs 10 to 12. The trial judgment, which you have seen, is at supplemental bundle 11, tab 11 and 12. Importantly, that ordered account pleadings. Now, the account pleadings are supplemental bundle tab 1 to 6. Now, before I go any further, I will, through most of this, focus on the pleadings of NT. And that is because in 2017, the agents set off on different routes. TT had avoided the new agreement of 2012 and therefore was entitled to an account on a slightly different footing, whereas NT was bound by the new agreement. And my learned friend is quite right that both parties ended up broadly, save for some APS schemes, with NT. So the focus will be on NT. NT's pleadings in the account of tab 4. I don't propose to take you through them in detail, but there was pleaded issues to do with the introduction of NSR, which I will come to, its components, and what commission was due under the various schemes. And those pleadings asserted original NSR as had been argued before Mr. Justice Ward in the first instance and had been taken to in his judgment. The defence, which is over the page at tab 5, sought to assert from paragraph 9 onwards revised NSR, or what was later came to be known as revised NSR. And there were two elements that are relevant here as to NSR, revised NSR. NSR, as my own friend has taken you to, is a 7% discount off net ticket price. Revised NSR is, however, the provision of the tickets to the agents with the ability for them to charge a passenger service fee or a YR code of up to 7%. As well as the obvious mathematical difference that a 7% discount of X is different from X plus 7%. There was the question, which we'll come to see in a second, as to whether revised NSR even was remuneration. The second issue to touch on here is the provision of the statement of practice. Now, I mention it here because it feeds into things that my own friend said about YQ being found within the net ticket price. PIA, in their defence, alleged that the statement of practice had been provided to the agents in 2010, and it had informed the agents of the move I'm going to deliberately say away from the historic commission to a new form of commission that was revised NSR. There was a reply dealing with this, which I don't need to take you to, which is tab 6. These matters formed the start of the first preliminary issue, the order for which is behind tab 15 in the supplemental bundle, page 139. Bottom, paragraph 4. Mr. Justice Warren setting out that there would be an issue in terms of the meaning and effect of NSR. The defendant, from relying on his emails, those were the emails allegedly providing the statement of practice. And thirdly, whether the agent productivity schemes for 2013 and 2014 ought to be calculated on the same basis as the 2012 agency productivity scheme. This is a pretty minor point, but Mr. Justice Warren's judgment in June 2017 had only dealt with agent productivity schemes up to 2012 and not 13 and 14. The judgment dealing with this is unfortunately only in transcript form. It's found in a supplemental bundle, tab 57, or was exhibited to witness statement of my solicitor, those instructed me, at page 400. It's not the most accessible of judgments, but the relevant aspects for it were at paragraph 10 to 12 of page 404. PIA had been ordered to give disclosure of the emails allegedly serving the statement of practice. They failed to give disclosure as the emails are sent, and the consequence of this was that they were debarred. Paragraphs 15 to 18 were whether or not an argument about revised NSR was one that PIA were stopped from making. The court found not. And at 20 it starts to consider the difference between NSR and revised NSR. Paragraph 25, Mr. Justice Warren grapples with how one deals with the provision of the tickets at a price with the ability to add a passenger service fee on. He talks about the agent price. And he concludes, considerably later, paragraph 63.
Sorry, what paragraph?
63,
Sorry.
page 416. For the PIA to allege revised NSR, they would have to amend paragraph 12 of their original pleadings, so their 2014 pleadings, where they had asserted original NSR. And then that pleading had carried through to Mr. Justice Warren's 2017 order, judgment. And finally, whilst we're also here, at page 417, paragraph 67, we come to the receipt of the emails enclosing the statement of practice, where Mr. Justice Warren finds as a fact that the agents did not receive the emails purportedly sent to them. There is in that judgment some discussion of credit. In one of Mr. Justice Warren's later judgments, he realises that credit is actually an unnecessary complication because it will be automatically calculated in the account. But if you're reading that thinking, what has happened to credit and why does it disappear? It was important then and later realised to not be relevant. This generated the order at tab 16 of the supplemental bundle, page 141. Which very shortly simply debarred the defendant because they had failed to provide disclosure. There was a consequential hearing.
Sorry,
Oh, sorry.
can I just keep up with that? So the debarring bit is... Oh, I see. Yep.
Yes, it's because the order behind tab 15 at page 139 required the defendant to disclose electronic copies in a naked format of the emails as allegedly sent. And the court found that it didn't. They disclosed copies of emails that had been received by other agents. And there was a realistic concession that the metadata between as sent and as received would be different.
And just to confuse myself,
Yep.
I knew that it had been accepted before Mr. Justice Barling that PIA was debarred. But here I find an earlier order barring it from defending the account.
It gets overturned by
Yes.
the order at tab 18.
Yes, I see.
My lord is quite right. In at the tab order behind tab 18, a consequential hearing in April 2018, the defendant gave various undertakings to the court of the claimant in relation to how they would deploy the emails, specifically contending it would not seek in any appeal or proceedings to contend that the claimants or either of them received the emails. Now, insofar as my learned friend said, the statement of practice was sent to all agents. The only example, the only time this issue has this issue has been considered twice. That was contended for in Warren's 2017 judgment, where he found that there was no evidence, and PIA tried to contend for it in their account defence, where they were debarred because of non-disclosure, and they were permitted, if you like, to rejoin, only if they never contended, or they will not contend, that my clients have received the email.
Yep.
The rest of the order is largely amendments to the 2017 order that actually fall away because they're either to do with time to travel pre-economic dress or NT's obligation to give credit, which we all later realised was an unnecessary complication, and the provision of written submissions in terms of further, like, consequential preliminary hearing. That resulted in another hearing ruling, and you have seen this before behind tab 20. You can take it to page 155, paragraph 9, in terms of the correct measure of NSR as in it is net sale remuneration, not revised NSR.
And just pausing there,
Yes.
you accept that it's to be calculated by reference to VAT, tax exclusive prices.
The net ticket price, yes, is the price less taxes so properly called.
Yes.
Yes. I mean, within this, Mr. Justice Warren, there's a bit of a, not only indicates that NSR is what is PIA provide, but that they were obliged to provide remuneration under the IATA regulations, and revised NSR, as far as he was concerned, was not remuneration. Paragraph 14, page 156, was Mr. Justice Warren's, conclusion that credit was not necessary to be calculated. That's because an account which showed ticket at £100, where the agents got it for 95, is obviously less than the discount they should have got. But the order that would be made on that would be the provision of another £2 rather than. So credit, thankfully, fell away. And Mr. Justice Warren also grappled with what happened when PIA sold tickets at different prices, which was the consequence of evidence that he had heard. That was because PIA had tendered evidence that indicated they were only adding the passenger service fee on occasion to those tickets they sold from their offices and not online. And this is where you end up at paragraph 20 with the idea that it has to be the lowest published fare. That then transpired into the order behind tab 21, which you have already been taken to.
Sorry, forgive me, and that works in favour of the receiving of your client by choosing the lowest number, because that's effectively the biggest potential
Yes.
discount compared to the way they were selling the tickets.
Yes,
I see, that's fine. Okay.
yeah. The concern from, and you'll see this in the account pleadings, the concern from my clients has been throughout that PIA were selling the tickets to the public at exactly the same price they were providing them to the agents, and therefore there was in fact no remuneration. And the fact that they might have sold one ticket at a counter at a higher price didn't change that point. So yes.
And as to whether that's in your favour or not, if you were comparing such a price with what you'd had to pay,
Yes.
then plainly having a higher starting point works against you. Because it looks as though you've got a bigger discount. Or is that... Am I confusing everybody?
No, if we bought some tickets at £100, if the lowest published fare is 150, then clearly we've had a discount, we've had a very substantial discount. If the lowest published fare is £100, then we've had no discount. I know there was a...
So at that stage, it's in your interest that the price is lower.
Yes.
In the end, when we get through to the account judgment, it's in your interest that the price is higher.
No, it's never
Because
in our
you
interest.
do not then get 7% of the higher price.
I think in terms of the account, there are two elements in the account. One, whether discount has been provided, and two, whether, if not, what the discount ought to be.
And in calculating the first,
Yes.
you're better off if the lowest prices are lower, because it looks as though you've got less discount, if any.
Yes.
But once the court has said, well, we don't accept there was any discount,
Yes.
then you're going to get a bigger figure if the price at which the tickets are sold to the public is higher, because you get 7% of the higher figure.
No, we got 7% of our figure.
Or however you arrive at it, the higher that figure is, the better off you, the more you get.
I think the point you're making is, if the figures are inclusive of tax, will that mean we get more? And the answer has to be yes, because that's 7% on both the core element and the tax element.
Yes.
So it's not whether the figures are higher or lower, so much as if the figures are inclusive of elements which they ought to be inclusive of, will we get more than we ought to? Yes.
And that, I think that's a more sophisticated way of putting the same point. I mean, the stage at which it's been decided that you are entitled to 7% of whatever,
Yes.
the larger the whatever, the more you get.
Yes, but our only options are, if you like, those prices are historic, so it's a selection between numbers that are historically available.
Yes.
But there's no suggestion, if you like, that there's no suggestion, for instance, that actually, let me start that again. Because what my learned friend said earlier was it didn't matter for the first question as to whether or not a discount had been provided, whether the matter was whether those figures were inclusive or exclusive of tax. And that's, in my submission, not correct. Because if you have a ticket for £150, and let's assume its core price is £100, and its tax price, everyone accepts this, its tax price is £50. Under NSR, it's only the £100 that gets reduced. That becomes 93, 7% off 100. You add the tax back on. The price, therefore, if you were comparing inclusive of tax, is 150 for, if you like, what it was sold to the public, and 143 as to what it ought to have been sold to my clients. If you don't remove the tax element, the difference, and you just look at the 150 in a compound fashion, 7% off 150 is, my apologies, if you compare the 150 and 143, not removing the tax element, the difference between those is less than 5%.
I'm not sure that any of this actually matters, but I thought Mr. Kirby's point was really, if you have apples and pears, you're in trouble. But if you have two lots of apples, it's all right. So if the figure that you have to pay is inclusive of tax, and the figure that PIA charges the public is inclusive of tax, does it matter?
I mean, for PIA, it would, because on the £150, they should have provided the ticket to us at 143. But if you, because when you strip the £50 tax element out both,
yes,
that's the discount.
Yes.
But if you don't strip the tax element out, the difference between 150 and 143 is less than 5%.
I think you're right. Does it matter in circumstances where it's been decided there was no discount at all?
I mean, in circumstances where it's been decided that there's no discount, it's difficult to see how it would matter. No. If I can go back to the order of tab 21, page 160.
Yeah.
And you'll see it starts with NT, which was more straightforward account at the time. NSR carries the meaning given to the judgment, as in it's not revised NSR. It's the lowest published fare. You asked, why do the headings that you were taken to at page 465 not match, if you like, net fare and base fare? And that's because, as you can see, by the time you've grappled with NSR, it's very difficult to pin down what the figure actually is. It's not the case that there's necessarily a line entry in the BSPs which you can point to and say, it's that figure. What you instead have is the parties having to account on a basis of what was the lowest published fare because there were, if you like, no CSP line which could be pointed to, or market net ticket price wasn't reflected in any document in a way that the court could say that line entry is the net ticket price.
Oh, I see. So the point, is this right? The point you're making is that the amount to be paid to your client on the account was to be calculated by reference to applying the lowest published fare for a kind of ticket to a whole suite of tickets which may well not have been sold at the lowest published fare.
Yes, so for every ticket that we bought, PIA was meant to provide the information that if at that moment you had gone and found the cheapest PIA ticket you could have bought from them directly, what the price was, that direct comparison. And so it wasn't so much whether PIA ever sold at that price, it was whether it was offering tickets to the public at a price that it was higher than we were buying them at that level.
Sorry, I was just comparing the headings in the spreadsheet. Which are those at 465? Are they?
Yes.
So the lowest published fare is G, presumably.
Yes. If you like information A to F, I mean A is just 1, 2, 3, the item number. B to F is all information about the agents. That's when did they sell the tickets, and the information that would make it relevant, that would change the cost of the ticket. When are you flying? Is it a return? What class are you flying in? All of those matters. That's the, if you like, the routing. And the ticket cost price to the agent, which obviously we know because we saw the ticket. The information, the comparator that was needed from PIA was G, the lowest published fare.
So I think I probably got lost. So was that not just asking for the lowest published fare calculated on an NSR basis, a net ticket price basis?
As in, should that alternatively read the lowest published fare exclusive of tax?
Yes.
There's no suggestion that at any point NSR included tax. So yes, it could have included the lowest published fare exclusive of tax. I mean, brackets they're properly called because obviously
Yes.
YQ was a tax, but not a tax.
Yes.
Looking just back briefly at tab 21. The obligations to produce the account in a standard form in an Excel spreadsheet is paragraph 2, including vouchers of 2B and verification of 2C. Notice of objections in the standard form, paragraph 4, with explicit reference to practice direction 40, paragraph 5. And this is the spreadsheets that PIA were ordered were not just disclosure of information. It wasn't a count.
Is that right? I mean, an account in a conventional sense would end up with showing the amount payable, wouldn't it? These spreadsheets were never going to show that.
What do you mean that the amount payable? They would show the amount the agent had paid and how much. So in my £150 example, they would show whether the agent had also paid £150. You mean there wasn't a column?
At the end of the day, you would,
It's just an Excel spreadsheet, so it would show you the totals.
Oh,
But
yes.
it would show you the totals of the lowest published prices. It would show the totals of what you had paid. But that wouldn't give you the answer as to what PII's liability was.
The account as ordered, the spreadsheet does not include the formula as to what is the difference between the lowest published fare and what the agents pay. No, there is no column for that.
So why is this an account rather than merely the raw material from which you do the accounting exercise?
Because if PIA had provided on every line entry the £150 to our £143 ticket, you would be able to see from that comparison that that was the 7% discount. And so you would only need a formula, if you like, calculating what was owing if you concluded from looking at it that PIA hadn't provided that discount.
And I quite follow. You would take your lowest published fare column. You would calculate 7% of each figure, and you would then deduct from that the difference between lowest published fare and the ticket cost price to agent.
Yes.
But that's not in the spreadsheet.
No, that's not in the spreadsheet.
So it's not really an account. It's giving you the evidence from which you can do the exercise.
I mean, in circumstances where the last step is, if you like, simply the application of a mathematical formula, if no discount has been applied, I think it was an account, because if PIA had provided at every point the requisite discount, that would have been, if you like, there wouldn't need to have been a totaling column. So if this account had only been 5 lines, obviously it wasn't, it was 120,000 lines, but if this account had only been 5 lines, and every ticket that we had bought, so for our column, it said ticket cost price to agent £93, and in column G, lowest published fare £100, that would be an account. I don't accept it simply because the size of this data was so large that the only realistic way to handle it was through Excel formula, that would rob this of being an account. There was, moving on through the various preliminary issues, behind tab 22, a further preliminary issue. This actually largely falls away because it was the basis of time travel's remuneration before economic duress. So by this stage, the account is, if you like, ordered, and we're now into execution or production stage. Behind tab 23, page 170, has already been taken to the defendant hasn't provided it, and there the borrowing order is made. It's then necessary to leave the account, if you like, the orders behind, and go to the second supplemental bundle to look at the charges before the court, what was produced. Tab 33 and a very similar witness statement to 34 in relation to non-union travel are the affidavits of PIA to which the spreadsheets were exhibited. Now you'll see at paragraph 7 that there's some discussion of the different classes within the ticket price that would affect cost. Paragraph 15 discusses the BSPs. settlement, which isn't fantastically relevant, paragraph 16 to 19. But paragraph 20, the explanation as to how PIA has the agent's BSPs. So this is the tickets the agents have sold. And then at the end of paragraph 21, the information that there is no BSP information for PIA's tickets. And actually one of our later complaints was that insofar as PIA provided any data about their own sales, that wasn't supported by evidence. Mr. Bagg, at paragraph 22, then expressly decides to consider what the order of 9th of July 2018 obliges him to do in relation to providing the account. And the various comparators. Now, the Excel spreadsheets are not before the court. For some suggestion of what information they did contain, you can see them, samples if you like, set out at 256, which have already been taken to 259.
Right, just before we go that, is some interest in paragraph 26. He confirms the details set out in the spreadsheet are accurate and correct.
Yes.
Have I got this right, that the spreadsheet data has come from PIA's mainframe, not from the BSP data? So it's not purporting to be an aggregate of the BSP data itself, although they should presumably you would expect them to reconcile.
I have to say, yes, it's not clear actually in relation to this whether they're discussing their own ticket sales that they are disclosing, or whether that is all the data they are disclosing.
Okay.
I think the point is unclear, and as events turned out, was never explored. This, I'm just working through paragraph tab 35, closest, produced in response witness statements from the agents and their notice of objections. And while we're at tab 35, if we could go to page 250, paragraph 6, which are like the heart of the complicating factors behind the account set out in Mr. Ahmed's witness statement, which is that unlike other airlines, PIA was not providing a public fare that you could see and a private fare. If PIA had been doing that, the information would have been apparent and obvious, but that wasn't what PIA were doing. They were only ever providing a published fare, which is what the agents were paying. So if you'd like to feed back in, my lord, to your question about why did the headings within the account not really match what was said in 2017, it's because as matters were further explored, it was realised that actually what was going on was quite divorced from what other airlines were doing, maybe what ought to have been happening. And so to many extents, this is the heart of the difficulty in how to construct the account. The notice of objections We look at Nottingham's, it's behind tab 38. The objections of page 266, as well as there being simply no information from PIA, were materially, there was no information at all, and an example of that's given at 268. Those three examples where you can see item 78 was sold by NT on the 5th of November 2012 from Manchester to Islamabad at £340, class U, lowest published fare in response from PIA, nothing.
Sorry, now I'm being stupid.
Yes, no, sorry.
Where does it say lowest published fare?
So if you look at page 268,
Yes.
and you do have to read these landscape because the Excel spreadsheets are simply so large.
Yes.
So I can see it is unhelpful. Reading from the bottom up, this is line number 78. It's date of sale by ticket by agent is the 5th of November.
Yes.
The ticket number ends 96.
Yes.
The routing is Manchester to ISB Islamabad.
Yes.
Ticket cost price to agent 340.
Yes.
Outbound on the 11th of November 2012.
Yes.
RBD, so that's the sort of class of the seat, class U.
Yes.
If PIA were going to provide data about their lowest published fare, it would either be at PK counter sales.
And I see, looking on at page 270, you see figures going in there.
Yes.
Yep.
Or PK web sales.
Yes, I see.
So the fact that in the top third of this page there is simply no information is because PIA haven't given an equivalent. Now across the two agents there were about 120,000 line entries. 20, from recollection, about 70,000 of those had no, there were simply blank spaces for equivalent data.
So 70,000 out of how many, roughly?
120.
120. So the majority.
Yes.
Yep.
So then we turn to what about the occasions when the PIA did provide equivalents. This example is 269, and we take line number 49. The date of the sale is the 2nd of November. Ticket ended in number 64. The return flight, Manchester, Islamabad, Manchester. The cost was 576. Outbound the 15th of November. Return the 12th. Class U and L. And here you can see there is information in PK's counter sales. But you can see the outbound information is the 8th of November and the return is the 30th. So we're looking at two completely different dates. And web sales, you can see at £586, PIA sold a ticket outbound the 15th of November and return the 14th of December. So that they have provided information, it's not equivalent. Just to complete, because this will, I think, assist in terms of what other schedules were filed, we go over to page 270. This was an occasion, there weren't many, where equivalent data or near equivalents have been given. And I say that because PIA are providing actual sales rather than lowest published fare. So at best, this is simply saying at some point they sold the ticket rather than when it was sold, what price was being offered when we were selling. But taking it at its highest, what does this information show? Line entry 9191 shows a ticket cost price of £776, and you can see outbound the 13th of October, back the 19th of November, and PA counter sales I find the 13th of October back to 19th of November for 776 as well. So these examples are where PIA was selling the same ticket, but either the same price, or if you go over a column, cheaper, where you can see for 15443, that ticket entry, the ticket cost to us was £382, and PK sold the same ticket at their counter for 28, which is, needless to say, a substantial undercut. So those were cheaper or the same, and then, in all fairness, because a very small number did exist, at page 271, you see where equivalent sales information has been given that suggests that there was at least some discount, but not full NSR. And so there you can see, for instance, 3101, we sold it for £415, and the counter sold it for £429. So those were the notices of objections. After this stage, the Court of Appeal came back on limb 1 in terms of economic duress. So the underlying account had to be modified. For various reasons, actually, this didn't involve a great deal of difference because both agents were entitled to NSR, just NT was entitled to it under the contract, and Time Travel was entitled to it on a quantum merit basis. But it was necessary to modify. And behind tab 25 was the CMC, so page 175, supplemental bundle 1. Necessary amendments are being made on page 177. Which is really bringing Time Travel onto the same basis as, or almost the same basis as Nottingham Travel, and the summary of the differences is set out of paragraph 29 of my skeleton. This was also the hearing at which it was raised that PIA's account was defective, and the issue as to whether or not they were adjourned. They were debarred, was adjourned. And then behind tab 26, the consequence of the adjourned hearing was that the defendant accepted that it was debarred. Now, to explain the rest of the order, the first claimant had obviously provided all of its account information on the basis of the account pre the Court of Appeal, so pre the economic duress on a different basis. So it was necessary that it then filed updated information to reflect the basis on which the account had changed, and that is at paragraph 1. At 2.1 is bringing interest up to date because obviously as time is marching on, so the interest calculations are becoming out of date. And 2.3 was to permit, was to require the claimants to serve any spreadsheets properly verified that they wanted to rely on. Now those spreadsheets aren't before the court, but the witness statements are. And if you could go to supplemental bundle 2, tab 40, page 4, I apologize, 275. This is the verifying witness statement. And if you go to 276, paragraph 7, it explains what the attached spreadsheet attached to this witness statement And in summary, what the spreadsheets that were filed by the agents in late 2019 were doing was handling PIA's data. It was analysing it to apply to the entire class of data the categories that I took you to earlier, where either there was no data, incorrect comparators, or where there were comparative sales, what that showed. And so, as you see at 7b, Schedule 1 of the spreadsheet was all the data where there was no comparators. So those columns were blank. Over the page at 277, Schedule 2, they provided counter comparators, but they weren't comparable, and 3 web, but weren't comparable. 4 and 5, where they had provided the same comparator information in web and counter, an analysis of that. And 6 was a summary.
So 4 and 5 would be doing the arithmetic on agreed materials, so to speak.
Yes, they would be showing if there was a comparator, what that indicated discount had been given.
Yeah.
And I'm just seeing if there's, in terms of how many comparators there were, page 281, paragraph 35, there were 57 line entries for counter sales, which matched agent sales, and 282, 115 line entries for web. And if you want the same information for NT, it's at page 293. For counter sales, there were 45 direct comparators and 50 for web. So out of 120,000 line entries, there were under 300 where there were comparators. You see in paragraph 39 on 282, PIA, my apologies, TT then analysed, or concluded, given the analysis that I conducted on PIA's information, what discount was owing. And you see for most of them, it thought that there was no discount because there was no comparators, and so calculated NSR due. For the direct comparators, Time Travel did give credit for the cumulative discount. And that is taking PIA's case as very highest, because you'll see from paragraph 37, in the direct comparators, there were occasions where the airline had undercut the agents. So there were direct comparators, but they showed that actually not only had no discount being provided, but actually the agents had bought considerably more. So when the agents were giving credit for discount that is cumulative across the class. The occasions that they were undercut were offset by the occasions they did get discount. And of course, and concluded that 266.4 price was due. Now, the amount that PIA, and I'll come on to why they're slightly different in a second, but the amount that was ordered was 2,665,000. So, and one of the points I make in my skeleton is that if we were to rerun this information or this exercise solely on PIA's information, actually the analysis has already been done.
Well, it's possibly been done on the basis of balance payable.
Possibly, but my point is, if you like, and this perhaps comes back to Justice Arnold's point, is that it would be necessary for PIA to falsify their own account, because it's not the case that, if you like, before the account judge, there was PIA's evidence which was ignored, and our evidence which was adopted, and ours was wildly wrong. Actually, before the judge, PIA's evidence was analysed, and the figures that we came to on an analysis of it was very close to our own analysis.
And if I've understood correctly, your analysis is, so to speak, filling in gaps and extrapolating from PIA's information.
There was, so this analysis was looking at PIA's data.
Yeah.
It was separate from the witness statements filed by the agents, where they had, like, the summary schedules of what they thought was due.
And that's what we see over the page at paragraphs 42 and 43. So 42 refers to the schedule which Mr Kirby took us to.
Yes.
And that's where we get the figure of 2,669,30251 from. And he points out the difference between the two is just under 0.2%.
Yes. There is a slight difference, and this is the point I make in my skeleton. The table at 285 gives credit to PIA for discount.
Sorry, explain that.
So, sorry, 282.
Yes.
The analysis is saying taking PIA's case at its best when it has provided discount and setting that off against the occasions where it's undercut us. What was the cumulative discount we got? And insofar as we've got it, so for instance, direct comparators, we got 128 fines.
Yes.
And so it was giving credit for the cumulative discount, because we should have had 1,462, and we were saying on the analysis perhaps only 1,332 was due.
Yes.
The account judge found that no discount had been given. So if you like, this was a generous interpretation of PIA's figures that weren't actually borne out, if you like, on the findings the account judge made.
So on that basis, you're effectively looking just at this table. You'd add £500 on to reverse the discounts that you've allowed for.
Yes, yes, and this is, yes, exactly. And that's the point that I set out in my skeleton. Paragraphs 83 to 87. The figure without the discount is 2,669.
I'm afraid this I'm sure is my fault. But if I reverse the discounts that I see in the table at paragraph 39, I'm just adding on £500, which gets me to
Not 5,000.
not 5,000.
Well, in that case, I might have made a mistake in my skeleton. It should be 2,664,500, the 2665 order?
Well, I think the explanation is that there were other discrepancies between the figures. I mean, your witnesses make that point in passing.
Yes.
Actually, there were other instances where it's not just a question of whether giving credit for the cumulative discount, but there were actually certain discrepancies in the underlying figures.
Yes, there were.
I don't know whether you're going to be able to help with this. As my Lord says, we come on to paragraph 42 to a reference to the schedule of claims, which, as I understand it, is seen at 285. And that gives the figure you do quote of 2669,302.51.
Yes.
So why is that different from 2664 plus £500?
Because the 2664 plus £500 is analysed on PIA's data. And behind tab 41, that is our own figure. Because whenever we compared the raw data sets, we find that there was a difference, a very small difference, but there was a difference between like the total number that PIA had given for all ticket sales and the total number that we had given.
Yeah.
So if you like, there wasn't between the parties a single agreed sum as to what the total value of sales was.
So
there's a small disparity.
I mean, this may be significant. Can I just try to understand it?
Yes.
We know we've got the BSP
Yes.
figures. That we've seen a sample at tab 49. And the hypothesis this morning was that if you totaled, totaled the balance payable figures for the relevant periods, you would come to the total ticket sales figures showed at 285. The 2,281,963.74 and so on. Do you see what I mean?
Yes, you would come to actually, it's not totaled, the total of the column, total ticket sales.
Yes, but if you took the period 1st of November to 31st of December and
Yes.
looked at the BSP material for that period and added up all the balance payables,
It should come out at 2.2 million.
yes.
Yes.
But since there is a small discrepancy between what you get to on that page and what you get to in paragraph 39 of the preceding witness statement.
Yes. Why and how? The point I'm just looking for was that the agents, when analysing the BSP data, did not come to the same global figure. I'm just looking for the reference. So for instance, behind tab 35, page 251, paragraph 12, you've been taken to this before.
Sorry, paragraph
12 at 251, I think it is, mine is still off the page. You'll see that when comparing,
it mostly did.
and the differences were nominal, but over 120 line entries, nominal. So there wasn't, if you like, a situation where the account judge was faced with a core agreed global core of figures to work from, because two parties had arguably done, in terms of the agent's BSPs, the same thing and come out at small differences.
Yeah.
And so that's why, there are rival figures between what PIA's data shows if you analyse it and what the agents were putting forward on the data that they had looked at themselves.
And yet, and that's even though, just if I'm absolutely clear, you're both working from BSP figures in this respect.
Both parties put in witness statements, yes, that said that they had looked at the BSP figures.
And so really they should have tallied. Something's gone wrong somewhere.
They should have. I mean, in the, as if you like, the account fell out, the differences were nominal.
No.
I think what actually happened is we went with the agent's analysis because they were ever so slightly smaller, if you like. That was the more generous interpretation to PIA.
Yeah.
But that's why we have, if you like, different figures.
Well, and one possible explanation for that is given in paragraph 17 on page 251. They didn't have some of the data.
Yes. Yes.
That would explain why it was slightly lower.
Yes. Although I don't think that applied for non-England travel. You also find nominal differences, which is 262, paragraph 14.
Yes.
So just at this point, pausing to think about what information was before the trial judge. He had the raw spreadsheets from PIA. He had the spreadsheets that the agents had taken PIA's data and analysed it to look for the comparators. And they could only do that with PIA's data because they obviously didn't have the information themselves about lowest published fare. They had the conclusion at the witness statements which detailed that analysis about what that showed or didn't show for NSR that ought to have been provided. And the account judge also had, separately, the agents putting forward, like, their own calculations based on their own BSP reports.
So is this right? By this stage, once we had the agent's own calculations, your clients were also making a mistake, putting it forward based on the price which included taxes, properly so called. Maybe didn't know how much, but it must have done.
The figures are almost identical. So if PIA was putting forward inclusive of tax fares, then given how close the figures are, I can't see any argument other than to say that our figures must have done the same because they are so close.
And do you accept that PIA used balance payable figures?
No. There's no, in terms of what they did, Mr. Malik's witness statement, even in the slip rule,
I mean, let's ignore Mr. Malik's witness statement for a moment.
yes.
I mean,
We haven't gone back to investigate. I think that's probably, if we're ignoring Mr. Malik's witness statement, the agents have not gone back to rerun the account or the analysis. Or to independently, if you like, try
or
to
check
know.
what they did.
Yes, no. Because the data sets that we're dealing with are huge.
I wouldn't have thought it was that difficult to run a program to total a column.
Within the ticket, well, I mean, you say that, and yet, even looking at the BSP data, both parties came to different totals on whatever column they were looking at.
But it would be an enormous difference on the figures we've seen between the balance payable figure and the gross fare cash figure, such that one could tell really very quickly whether...
But that presupposes that gross fare cash is the correct...
No, but that's a different
Yes.
point. But in terms of what PIA was working from and in terms of what you were working from, since you were looking at BSP figures as well, it wouldn't take anything at all to work out which column was being used, I'd have thought. Because the difference in scale would be so great.
beyond saying that we haven't gone back to redo, if you like, the calculations or look at what was done or ought to have been done, no, we haven't. If you, in terms of, we haven't explored whether PIAs, if you like, calculations on the basis of gross fair cash are correct. Because this is just, in many extents, we have done the analysis for the account. We did it throughout 2019. This is not, if you like, something that my client ought to be put to because the account is over. And to that extent, this is not a cost-neutral exercise to rerun the analysis. So no, we haven't. Yes, 40 and 43. We then go back to supplemental bundle 1, tab 27. This is the first element in the taking of the account. What does to borrowing actually mean? Although I don't think the point is controversial, page 196, it includes the defendant being not permitted to adduce further evidence. That's paragraph 55, sub 2. The account judgment, the core bundle, tab 6. There, the court finds that despite occasional examples of discount, that no discount has been given. It then had to grapple with, well, on what basis was NSR going to be calculated? Because it was 7% off lowest published fare. So in the absence of lowest published fare, what was the appropriate data to use? And the court concluded it had to be the agent's ticket price. And that became then the judgment that is tab 5. Now, Lords, very briefly, in terms of the definitions that we've been kicking around, historically, in historic commission was due on the fare applicable. The issue before Warren was whether YQ was part of fare applicable. The necessity to differentiate between when YQ was included and not included is what led to base ticket price and net ticket price. My learned friend has taken you to those. The agent productivity schemes, which my learned friend hasn't actually dealt with. The order at tab 12 of the supplemental bundle and page 130, little Roman numeral 4. Says that the agent productivity scheme should be calculated on base ticket sales. Now, despite the various pleadings I've taken you through and the preliminary issue, which grappled with whether the agent productivity scheme in 2013 and 14 was the same as 2012. PIA haven't suggested, to my knowledge, until the slip rule application and this appeal, that base ticket sales was the same as base tickets, as in excluding YQ. That wasn't an issue that was articulated. And bearing in mind that YQ was now was found to be part of the commissionable fare. So in terms of my learned friend's submission that there are two forms of commission, NSR, which is net, so including YQ, and the APS schemes, which are base, as in excluding YQ. My submission is that point wasn't made at any of the pleadings that I have taken you to.
So your case is that APS is calculated by reference to sales including YQ.
My case is that we pleaded, I get that the figures for the APS schemes were, for instance, tab 4 of the supplemental bundle, page 35, paragraph 22. The issue in the preliminary issue was whether commission was tiered or banded. So there were, the first 1,000 tickets you sold, you get 1%. For 1,000 to 1,500, you get 1.5%. If they were tiered, which is what the court found, then you only got the 1% over 1,000, the 100,000 to 150,000. So you would feel like there was a maximum amount you could get. What the agents wanted to clarify in the preliminary issue was it the case that if you sold 250,000, you got 2.5% on everything, or you only got 2.5% on that particular tier? And the court said no, it's tiered. So you only get the 2.5% on the sales that fall within that particular band. That was the only issue of the that was the only point within the proceedings since 2017 when there has been any discussion of the basis on which APS should be calculated.
And if we go back to your paragraph 22 of page 35,
yes.
Is that calculated? I mean, what can't you say whether it's calculated on the basis that YQ is included?
That was, I don't think I'm able to assist you on that. I think that this must have been calculated given the agent's position on the basis that was rejected by the court, as in...
I see, yes.
If you got to 250,000, it didn't mean that you got 2.5% on all of the sales that you had made.
But that doesn't help on the YQ issue.
No, it doesn't.
Yes, I see. Yeah.
The final point that I wanted to turn to was the statement of practice.
But, sorry, just before you do, not looking at the history, but looking at your case now, if there were an issue to going forward, it would be your case that you were entitled to APS calculated by reference to prices including YQ.
We haven't, if you like, had to take a position on that. So no, we would need PIA to plead it and us to reply to it, because I feel like no one has ever investigated. In the taking of the account, this point has never, if you like, been thought about. So I don't have a case on it because we've never had to explore it.
But does any of this matter? Because there's no appeal in respect of APS, as I understand it.
No, there is an appeal in respect of APS. So PIA say that both the NSR figures, which they say is inclusive of YQ, and the APS figures, which they say is exclusive of YQ, can both be calculated on gross fair cash. Which obviously is, they both can't be correct. But it comes back to the point that no one knows where YQ is.
But if it were the case that you accepted that APS could be calculated, was correctly calculated without regard to YQ,
yes,
then the gross fair cash payable figure would be fine, wouldn't it?
if YQ is in tax, yes. But if, as the PIA say, YQ is in gross fair cash,
Well, then it might be overly generous to you, but you couldn't be disadvantaged by using gross fair cash.
we could be, not in relation to APS. So
Not-
if,
yeah.
yes, if YQ is not in gross fair cash, and so therefore gross fair cash is a base fare, then on PIA's case it's the correct fare for the APS schemes. But the other side of that is, it means when you come to calculate NSR, it's not.
I see that, but separating out the two aspects. If it were the case that you accepted that YQ didn't come into APS, then a calculation by reference to gross fair cash could only be generous to you. It could either be right or generous to you. It couldn't be adverse to you.
It could be adverse to us if things that were, if you like, the applicable fare, the form part of base fare excluding YQ, were fees within the tax stroke fee cash column. This is the problem. We have no idea what falls within those columns. So there could be elements that are, if you like, the applicable fare on which APS ought to be calculated, which could be in the tax stroke fee cash column. We don't have any, if you like, any way to take that any further about whether it be advantageous or disadvantageous. Very briefly, turning to the statement of practice, this is actually in the core bundle. Tab 13, page 119. And my learned friend said that all of the agents had been notified of the change to NSR.
I didn't actually say that one, but I'll come back.
Oh, my apologies. I said it should be there. It was sent to the agents. And the SOP showed that YQ had merged with the net fare. If that's not completely accurate, I'm sure my learned friend will correct it. My submission is that this document doesn't help the court for two reasons. The first is that this document is what PIA put forward in favour of revised NSR, which was rejected. And the second is that this is the document that was attached to the emails, which was subject to the preliminary issue in December 2017, where Mr. Justice Warren found as a fact that these emails were not received by the agents.
I mean, I'd see all that, but if it were the case that this showed that from this point onwards, YQ was going to be included in gross fair cash, neither of those points would matter, would it?
I mean, one would have to test whether or what weight could be given to this document. But I can see that if it said YQ is in gross fare cash, the court might think that was quite a good indication.
So, I mean, it's the truth that really and truly the 2 points you've mentioned don't matter. The question is whether one can extract from this document sufficient, whether one can infer from this document that YQ has been put into gross fare cash. And there you say you can't.
There I say you can't. It's also, not only does it not mention gross fare cash, it says net stroke net base fare. Like, the weakness or the issue with it is the idea that it was being merged and what no separate YQ means. Because this document is 2010 and YQ and its application was an issue in the original trial up to 2012. So, my lords, and thank you for letting me take you through that. I know it's voluminous. As for my skeleton, my first, primary point is that the judge was entitled to come to the view on the material that was before him. The APS figures were agreed. And the NSR figures, I've explained how different calculations of those came about. If, my learned friend would suggest, was counterfactual, what if the tax issue had been raised? Well, at that stage, and despite, as you see, the very extensive degree to which the preliminaries of this account have been thrashed out, at no point had PIA suggested that gross fare cash was the appropriate basis on which to take either NSR or APS. If that had been the case, it would have made the headings in the spreadsheet much easier, and we would have probably avoided a number of the preliminary issues. My second submission is that if there was, as PIA now allege, a disconnect between what was ordered in 2017 and what was actually being calculated in the account in December 2019, my submission is that that error, which it appears to be accepted was a misapprehension on both sides, was primarily made by PIA as the accounting party. Now, it's fair to say of paragraphs 72 to 75 of my skeleton, I speculate if they had made a decision, an election, as to why they might have made that. The short point is that if PIA were in fact doing revised NSR on the ground, what they were doing was adding a passenger service fee that would only show up in inclusive of tax. And so therefore they had an election between inclusive of tax fees that would show a potential discount, or exclusive of tax fees that on their own case would not show a discount because it was an element that would be excluded. 72 to 75 is pure speculation as to what they might have done. I don't think the court needs to go there in terms of what actually did happen. But the suggestion that this was purely the agent's error isn't correct. And you can see the closeness of the figures at the table, paragraph 87. In that the parties disagreed about the core BSB total. They were, for the size and number of line entries, pretty close. So my final 2 points are, well, what would happen if the court did remit this? And if PIA were allowed to assert, despite having not done so since 2017 in any of their account pleadings, that actually gross fair cash was the correct basis, they would have to at least refile the account spreadsheet of January 2019.
I wonder whether this is quite the right way of looking at it, because supposing we allowed the appeal and remitted it,
Yes.
I'm not sure that PIA would be doing anything. It would then be for you to come back before the court and address the judge by reference to the materials that were already in, as to whether he could conclude that 7% of whatever figure was the right figure. I'm not sure it would be a matter of PIA refiling anything.
No, but in that case, I mean, if we run through that hypothetical of what would happen, insofar as PIA or this judgment sought to suggest that the evidence that my clients had filed was incorrect, I would seek to simply rely on PIA's own account. And they, because they were debarred, wouldn't be able to falsify it. So I would be, and if we look at supplemental bundle 2, for example, page 256. So this is the, if you like, a small sample of what the PIA spreadsheet, account spreadsheet looks like. So I would take the judge to the line entry of the spreadsheet and say, there was no discount found, that matter is not put in challenge. On what sum of the court to quantify 7%? Well, there is ticket cost price. There would be no suggestion I would be obliged to say to the court, by the way, PIA maintained ticket cost price is the wrong price, and it ought to be a different price.
I don't know if you got that far, there might be. I mean, if you got that far, it would be on the basis that it seemed that the balance payable was the wrong figure. And the judge might then want you to explain whether you were working from balance payable or something different.
Potentially, yes, I can see that. But in terms of, if you like, what investigation this would entail, but we don't quite know what is under the bonnet lid for that point. Because it's not as simple as saying, oh, it's just gross fair cash.
Is APD a value-added tax?
I'm so sorry, I didn't hear that.
Is APD a value-added tax?
I'm afraid I don't know. I don't know whether it falls within the tax.
I have to say, one of my daughters knows about APD, And it's not VAT in the strict EU type sense. It is a separate tax.
Yeah.
But it is an indirect tax.
Yes, but does it work on the same principle, namely that you charge each time you go down the line, and then you deduct your inputs from your outputs?
Oh, I see. I'm afraid, my lord, I can't assist you with that. If you like, the government-imposed taxes have never been in dispute in this appeal, and so therefore I can't, I'm afraid, assist you with how they work. It's only being airline-imposed taxes and charges which have been, or at least those items which they've decided to call taxes and charges, which have been an issue. And so those are the only ones I have detail on.
Well, because if it's not a value-added system, then the cost priced to agent wouldn't include APD.
No, it wouldn't, because they'd be able to reclaim it. But unfortunately, my lord, this is a point that we've never had to explore.
Ms. Murphy, I know it's late in the day, but can I just make sure I've not misunderstood something? Something you said which I hadn't appreciated a little minute ago. Is this right? What was supposed to have happened on the basis of the way the account was set up was that what was meant to be assessed was the difference between the discount applied to the lowest published fare and the amount that your client actually sold or bought the ticket for.
Yes.
That was what was meant to happen. But it didn't happen at the account. When the account came to be taken, the judge decided, no doubt maybe on your submission or not, I don't know, it doesn't matter. But the judge decided not to do that because the judge decided that that couldn't be done. And so instead what was done was the percentage was taken based on your client's price.
Yes.
And it's only when you take that step that you start looking back at the gross fee cash figure. Because what was meant to happen was that the discount was meant to be calculated based on something completely different, which was the lowest published fare figure.
No, because what should have, if you like, if you're still in tab 36, if you go to page 259, which were, if you like, where there were comparisons.
Right.
So there's no suggestion from PIA that, if you like, they gave the agent's gross fare cash figure and their own total payable. I think their position is that everything was total payable. So what should have happened is for line 16275, 471 should have been compared against 496. And if 496 was, my apologies, if 471 was 7% lower, because 496 was the lowest published fare, and 471 is what we actually bought it for, and we were entitled to be 7% less, then we would have had full NSR,
Yes.
nothing payable.
Exactly.
Because in the 120,000 line entries, there were under 300 comparators. The court was then faced with, well, what do you do when there's, given we just work off lowest published? And there the court was decided that the only thing it could do was look at the agent's price, and so treat whatever the agents had paid as if that had been the lowest published fare.
Yes. So what you collected was 7% of 471.
Yes.
But what would have happened if the lowest published fare had been lower than 471?
That was a problem, because we could see examples where we had been undercut, and so the position that the court came to, bearing in mind that there were some examples where we had been, I'm afraid to say, wildly undercut by many hundreds of pounds, and some occasions where we were given some discount, and most occasions where we had no information. The only thing the court could decide was that there was no discount at all, and that meant that, like, on occasions where we were undercut, we lost out, because actually we didn't, not only did we not get the discount, but we actually were positively hampered. And on the occasions when we did get a little bit of a discount, that was ignored. So if you like, the court took a middle road that there were examples of undercutting and examples of discounting, but it couldn't resolve either way, so it therefore just had to treat it that there had been no discounting.
Well, I understand. It's a pragmatic way of coming at a number which you actually know is wrong. It's the best you can do.
Yes, because we didn't have...
You can't know it's the right... You know, in fact, you know for sure, really, it's definitely not the right number.
Yes.
It never will be. But it's a pragmatic approach based on the limitations of the data you've got.
Yes, absolutely. And there were, I mean, I think there's an example in time to travel, notice of objections. I thought it might be NT notice of objections. Which I took the court to earlier, page 270, where we saw the ticket at £382. This is
yeah, sure, no, I remember.
Yeah,
exactly.
in 28. So there were examples of...
No, I get it.
Yes, but in the situation where the court... The 300 line entries where you have comparators is not sufficient to be statistically useful across the entire data set.
Forgive me for
Yes,
interrupting you, just to complete the thought that's in my head, just any illusions. When you look at it that way, it's not at all obvious that you've received a windfall for £2 million. You may well not have done.
No, because we just don't know. We don't have the information.
Thank you.
My lords, unless I can assist you any further, I mean, I'm not going to make finality point because I think it's quite obvious. Safe to say that Mr. Bell and I have laboured over many months of preliminary issues and the current proceedings, and it's been. But the PIA have had many opportunities to raise these points. It's not just that they've had. This is post-judgment. This is post two judgments, 2 rounds of pleadings, many preliminary issues, a number of CMCs. This has been years of litigation to work out the basis on which the account ought to be taken. Now, I've referenced in my skeleton argument Smith, paragraph 41. That's where the appeal was 4 years late. I'm not suggesting, obviously, the appeal is 4 years late. But if we look at the length for which these issues have been in review, they did start in 2017.
Now, you definitely need to wind up.
I was going to say, unless I can assist you any further, that was my point.
Thank you very much. Mr. Kirby.
I will be very brief. My Lord, can I just come back on a very few points? My Lord, despite the best part of 2 hours, we still have no indication, direct indication, or direct answer to the question whether the figures put forward by the claimants included tax. Now, the position on the slip rule application was that a different explanation was given for the figures as to why they didn't have to exclude tax. My Lord, there's nothing more I can say on the point, but it is to suggest that no inquiries have been made or that the account has not been recalculated. That may be true, but the claimants in our submission must know whether the figures that they have used were inclusive or exclusive of tax. Well, secondly, and I apologise if I gave a misleading impression earlier, so far as the statement of practice is concerned, I'm not relying on it from 2010. I'm relying on it because it's referred to in the new agreement at paragraph 5, and that therefore it's incorporated within that. And as I say, I reference paragraph 5 of the new agreement. The new agreement itself is in the core bundle at, I think it's divided 14, sorry, yes, 14 and 15, depending on which claimant. My Lord, the claimants did file their own spreadsheets with their own raw data. My Lord, it wasn't simply a question of analysis of PIA's data. And my Lord referenced that, my learned friend's skeleton arguments in relation to the slip rule application, page 434 of the supplementary bundle at paragraph 59 and page 438 at paragraph 79, which refers to the claimant's data. My Lord, my next point, and perhaps the most important, is that, yes, this matter has gone on for a long time, but there has been one consistent aspect of it throughout this period of time, and that is the use of the definition of NSR and its repeated use. That did not usurp, that was not usurped by any headings on spreadsheets. That was not varied by any subsequent orders. That was the test, and that was the definition in paragraph 8 of the substantive judgment of this Justice Warren. Well, I said I'd be brief. I hope that was brief enough.
Thank you very much. As you'd expect, we will not be giving judgment here and now. In the normal way, you'll be supplied with the judgments in advance of hand down for you to correct typing and similar things, but not to re-argue the case. We would hope that in advance of hand down you can agree a consequential order. If there are points on which you disagree, could we please have brief submissions in writing, and we'd expect to settle those in the order that we make. I think in accordance with the practice that has now become normal, the hand down will be electronically rather than in the courtroom, but even supposing it were in a courtroom, then there will be no need, of course, for anyone to attend. Thank you both very much for
Thank you very much.
very clear and helpful submissions, and we'll leave it there.